deposition with respect to some information that she was not questioned about, and prior counsel didn't have reason to ask her about those things because they were unaware to ask. That's what we're asking the court's permission to allow us to do, and have discussed this, and the state respectfully disagrees with our position, I think.
If I may. So, Your Honor, the issue was that I received this envelope yesterday afternoon. So it's still sealed. I haven't had the chance to even open it. I'm assuming that this contains material that he wants to question the victim on, but in court on the 2nd, during docket day, Mr. Flowers said that he had provided this to my office, but the office didn't have it. We didn't have it. After we left court in the afternoon on Tuesday, docket day, I received an e-filing of reciprocal discovery saying that the thumb drive had been delivered. However, has this envelope shows, the stamp shows that it was stamped on September 2nd, 2025. So.
She's right. I thought I had sent it before my staff told me I had, and I was mistaken.
Yeah, it was mailed out, possibly September.
Oh, it was mailed September 2nd.
Yes, I received it on 9/4/25, yesterday afternoon.
Okay.
Yeah.
When you're talking about stamp, I thought it might have been, the received stamp that the state attorney's office often stamps on things.
No, it's the postage
Okay, I
stamp.
got you
Yes,
now.
Your Honor. So, again, I'm not able to offer even an argument because I don't know what this thumb drive contains. So I would say that for the purpose of the motion to redepose the victim, that we move it to whenever the court prefers. I would say even the 25th, because
I'm fine if the state wants to look at it to make a reasoned.
And we've just been talking about this for like 3 weeks.
well, we've been talking about this, Your Honor, since prior to last pretrial. So it's been
Judge,
more than 3 weeks.
Judge, can I be heard?
Go ahead, Mr. Flowers.
In the previous case, I told counsel that I believe her. Back to the last case. Now she's telling this court that she doesn't believe me. I'm a little tired of this. I told her a month ago what it was going to show. I thought I had sent it to her and I was mistaken, but I told her what's on that disc, and I told her about the emails and what they say and why I wanted to take her deposition. So for her to suggest she doesn't know is disingenuous, and I'm getting a little tired of it.
Well, I would disagree with that, Mr. Flowers, because telling her what you say it says versus letting her take a look at it.
I know that's different.
Are two different things, and I think that the state should be able to take a look at those things before,
And I
so
agree.
they can make their proper argument as to whether or not you should get another chance to depose this victim.
Your Honor, I agree with exactly what the court said, but to suggest she didn't know, I'm getting a little sick and tired of this. But I agree that she ought to have the opportunity to argue. I agree with the court's position.
So what are we asking for as far as a date? Do we want to have to bring it back for another hearing? And I mean, this is at least the third time we've talked about this after the motion on this particular issue.
Your Honor, I can just say that based on the representation of Mr. Flowers of what this evidence may be about, I do have an objection, has two relevance, first of all, and good cause, and then protection of the victim under Marcy's laws from harassment.
Okay, well, and I don't know what,
Right.
I think y'all approached the bench at one point, again, weeks ago, to tell me what was was going to be turned over, but I don't know the details of it either. So whether, for the court to make a factual determination as to whether or not another deposition's warranted, or is it harassment of a victim, I can't make that determination until y'all tell me what it actually is. So I would suggest you take a look at it. Once you've made that determination, let's come in for another argument on what it actually is. If there's concern about it being harassing or embarrassing content, then we can certainly do that in a smaller environment. But I can't make a determination until I know exactly what it is.
I agree with your assessment, Your
All
Honor.
right, thank you. All right, so do y'all want to put it on what, the 25th is my next miscellaneous date. We can put it on the afternoon. It'll probably be a little shorter of a, or smaller of a docket.
It would be fine for the state, Your Honor, whatever.
We agree.
Go ahead.
Yes, sir.
Okay. Let me just make sure. Let's put it for 2 o'clock on September 25th for purposes of argument, if more arguments needed on the deposition issue. Otherwise, the pretrial is still set for October 27th.
Very well.
at 9 o'clock.
Yes, thank you, Your Honor.
All right, thank you.
Judge, that's all I have. Thank you.
Have a good day. Anybody else ready? No? Mr. Kleins, Mr. Nopes? Mr. Williams? Somebody?
Judge, I can go ahead and go with Mr. Hinesley. Judge, the good news is it looks like Stack is up and running.
Yeah.
I have been working on the motion and limine in the case.
If you are the meeting host, please enter your host key followed by pound.
Not sure what that means. I know they're doing some work in courtroom D, which is why we're over here, but I'm not sure why it would have done that. All right, go ahead, Mr. Williams.
At any rate, I will be filing one. Because of that, I'll ask that we go the second week.
So when are we going to hear the motion?
I anticipate it'll be done possibly later today. I'm going to say Monday at the latest, and we can schedule it. I don't know what the court's
I'm just not
docket's
sure
gonna look
how
like.
convenient it's going to be, depending on how many trials we have. So I think
Yes, sir.
probably be good to get to the end of the docket, and we can really figure this out as to what days are going to be used for which trials. How long
Yes,
do you
sir.
think the trial is going to be for Mr. Hinesley?
Well, Judge, it's going to be the state's case. I think that they're going to plan on calling more witnesses than hopefully they'll be able to after I file the motion in limine, but I'd have to defer to the state as to how long they think the case will take.
I would anticipate, Your Honor, excluding jury selection, at most 2 days.
2 days plus jury selection. All right, well, anything else that we need to talk about before we start making a schedule at the end of the day?
I don't think so, not from the state.
defense, Judge.
All right, well, stick around, Mr. Hinesley, just so we can make sure to tell you when to come back. We just got to figure out some logistics on the other trials and which ones are going to go which days.
Okay.
Yes, sir.
All right. Anything else, Mr. Williams?
Not on Mr. Hines' case. I've got another case, but I would like to have 5 minutes in the conference room with him before I call.
Is that Mr. Horn?
It is, Judge.
Okay. All right, they're putting them back there for you. Anyone, Ms. Rivers, are you ready?
Your Honor, on we'll do the out of custody first, that'll be easier. John Rockus,
Rockus?
I'm sorry? I am. Your Honor, this is John Sherman Rockus before the court, 25 CF 675. We've reached an agreement, if I may approach.
Ms. Rivers? Rockus, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
John Sherman Rockus, 10/14/1973.
Mr. Rockus, you're here in 25 CF 675, where you're currently charged with kidnapping or false imprisonment, which is a third-degree felony punished by up to 5 years in state prison, and count 2, domestic violence battery, first-degree misdemeanor, punished by up to a year in the county jail. Do you understand what your current charge is? All right. I've been handed a plea and sentencing agreement between you and the state that the state would, in return for a plea of no contest to a non-domestic violence battery on count 2, that the state will dismiss count 1. Your agreed-upon sentence is basically just cost, $622 in court costs, $50 cost of prosecution, $50 PD fee, and a $50 application fee. And I can give you a period of time to pay that or set up a payment plan with the clerk.
Sure.
Is that what you want to do today?
Sir, it
Is
is.
that the state's agreement?
It is, Your Honor.
Okay. All right, Mr. Rockus, did you go over this plea and sentencing agreement with your lawyer?
Yes, I did, sir.
Did you understand it?
Sir.
Did you sign it?
Yes, sir.
All right, do you need any more time to speak with your lawyer about it?
No, sir, I don't.
Are you satisfied with her representation and advice?
Absolutely.
And are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? Do you understand by entering the plea there won't be a trial of any kind? And you understand you're giving up your trial rights, which are on page 2 of that agreement that you've signed? And do you understand you're waiving all potential defenses that you may have? And do you understand that by entering this plea, if you're not a U.S. citizen, you could be deported? And so what is your plea to count 2, which will be, I don't know what I'd really call a lesser included offense necessarily, but a non-domestic violence battery?
No.
No contest, sir.
I'll accept your no contest plea is freely, voluntarily, and knowingly given. State have an announcement on count 2.
The state dismisses count 1.
sorry, count 1.
Yes, Your Honor, in exchange for a plea to count 2.
All right, I'm going to adjudicate you guilty on the simple battery. 622 court costs, $50 cost of prosecution, $50 PD fee, and $50 application fee. I'll give you a period of 60 days to either pay those fees and costs or set up a payment plan with the clerk's office. Otherwise, it'll be a judgment against you. All right. Any questions? All right. I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence.
Thank you.
Thank you.
Your Honor, the next case is Bobby Simmons, 25 CF 1119.
Yes, ma'am. Mr. Simmons, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth?
Bobby Wayne Simmons, 32275.
And Mr. Simmons, you're here in 25 CF 1119, where you're currently charged with felony battery, which is a third-degree felony punishable by up to 5 years in state prison. Do you understand that? Okay. And I've been handed a plea and sentencing agreement that would call for you to enter in a no contest plea to the lesser included offense of misdemeanor or simple battery, non-domestic violence. And your agreed upon sentence with the state is $622 in court costs, $50 cost of prosecution, $50 PD fee, and an application fee of $50. And as you just heard in the previous case, I would give you some time to set up a payment plan or pay that off. Is that what you want to do today? Can you speak into the microphone just a little
Yes,
bit?
sir.
Okay, it's just when there's any ambient noise, sometimes it's hard to hear, and if I can't hear, I want to make sure that's working. I make sure the microphones are picking everything up, and sometimes the microphones end up getting shut off, and we don't realize that until later on. All right. So, Mr. Simmons, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And do you need more time to speak with your lawyer?
No, sir.
Are you satisfied with her advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Did anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
And by entering a plea, you understand there's not going to be a trial of any kind.
Yes, sir.
And you understand you're giving up your trial rights, which are listed on page 2 of the agreement that you signed.
Yes, sir.
And did anyone, well, I think I went to that part already. Do you understand you're waiving all potential defenses?
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the lesser included offense of simple, non-domestic violence battery, first-degree misdemeanor?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. 622 court costs, $50 cost of prosecution, $50 PD fee, $50 application fee. I'll give you 60 days to pay those fees or set up a payment plan with the clerk's office. Otherwise, they'll go to judgment against you.
What would the judgment be, something like that? I mean,
I can let your lawyer explain it, but basically it's like almost like if someone had sued you and got a judgment against you. And so it could affect your credit and things like that.
all right.
All right? Adjudication of guilt, yes. All right, so Mr. Simmons, I need you to come up to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. Thank you.
Thank you.
Last out of custody, I'm not ready on yet.
Okay. Go ahead.
Diana Malone. Your Honor, Ms. Malone is before the court on 21 CF 923. This matter is currently set for a jury trial. We were unable to get service on Dr. Zeman, who is essential for this case, so we're going to request a continuance at this time. We're in the process of trying to see if we can work out an agreement with the state, and if so, we'll ask to have this put on earlier.
State have any objections?
No, Your Honor.
All right. We're going to continue Ms. Malone to the next pretrial, which will be October 29th at 9 o'clock. If y'all come to some sort of resolution, you can certainly bring it in earlier. If you do set it for something earlier and it's going to take a decision by me, I know we talked about that and you provided some case law, Ms. Rivers. Make sure you give me a heads up that we'll be having some sort of contested hearing or something like that, so I know to prepare for it.
Yes, Your Honor.
Yes, Your Honor.
All right, thank you.
I'll let you know as soon as I know.
I'm extending to Mr. South is a plea to only one count of aggravated battery. In that way, he will score approximately 20 months. He has already served over 20 months, so the state will stipulate to the credit, and he will be released.
So it's no probation?
No probation.
Okay, just want to make sure.
And I would just ask that you not make a decision right this minute, and that you go and think about it, and that we bring you back at the end. Okay?
Okay.
All
Mr. South, we'll bring you up later today.
And I'm gonna want to talk to him in the interview room. Thank you. All right. Okay. Your Honor, this is Richard Wagner before the court on 23 CF 2526, and we are ready for trial.
Yes, Your Honor, the state is ready as well. If I may place on the record the maximum prison exposure that Mr. Wagner would have. He's currently charged with 2 second-degree felonies, which would 1, 2, 3 total, 3 second-degree felonies, and that would mean 45 years DOC maximum and 2 misdemeanors.
Well, then, total of potentially 47?
40, well,
One of them's
it's a.
punishable by 60
one
days.
One's
is-
a 60, okay.
Yes, Your
I
Honor, one is
wasn't
a
sure about
second
the-
degree, one is first degree.
Okay. So 46 years and 60 days is the maximum exposure. Do you understand that, Mr. Wagner? So that means if you go to trial and get convicted on everything, I can sentence you up to basically 46 years in prison and 60 days. You understand that? Okay.
Yes,
Is
Your Honor.
there any plea offer that was made that y'all want to put on the record?
Well, Your Honor, not for this particular case, because he has additional cases, so not for this.
Mr. Wagner, do you need any more time to speak with your lawyer before we set a trial date? Okay. How long do y'all think the case will take?
Jury selection in 1 day.
You agree with that, Ms. Rivers?
Yes, I do.
Okay. And are y'all asking for one week or the other?
We would prefer the second week.
But you wanted the first week.
We subpoenaed for both weeks,
Okay.
but I don't
Are-
know other trials, how long they're gonna take for the first week.
Okay.
Let's just kind of figure it out, and then we'll make a decision at the end once we know how many trials we're going to have.
Thank you.
That would be fine, Your Honor.
So we may bring you back up just to tell you what week you're going to be, what days. But we just have to get to the end of the docket to figure out how many trials we've got and how many, how we can schedule and to fit them all in.
That's fine.
All right, thank you, Mr. Wagner. Your notes, are you ready?
I'm not yet. Just ask to state something.
Okay. Okay. Sure. I'm just waiting for all the cases to be ready.
She is not on today's docket, Your Honor. This is Tony Henderson. She was on Monday's docket. The court issued a Capias. But I believe, Your Honor, I had said if we can get her into court, the court would consider withdrawing the Capias.
Certainly consider it if I'd given an explanation.
Well, Ms. Henderson has relayed to me that she didn't understand the court date. I believe she had, well, I'll turn it over to Ms. Henderson. She can explain it.
Yes, sir. I got my court dates confused with, I have got court in Alabama too, and I got a court date of the 9th. And I just got my door, I'm so sorry.
I understand. It's just we want to make sure that people are showing up at court.
Yes, sir.
You were just here the week before when we gave you that court date.
Yeah, and I thought I heard you was giving out a court date of the 8th or something too, and let me just shut up now.
You can certainly tell me what you want to, if you'd like to, Ms. Henderson, but I may have said the 8th for someone else, but that's the
Yeah,
start of our trial week.
Well, I got it messed up from the get-go, like I was left, I come in early and then y'all told me to come back at 1 o'clock at one court date, and then the next time I come in and I thought I was supposed to see one lawyer and I was supposed to see somebody else, and so I left. And so it's been just messed up.
I'll tell you,
I
Ms.
will
Henderson, anytime you come to court and you're in the courtroom, you probably shouldn't leave until you've talked to the judge with your lawyer, as you're doing right now. Otherwise,
Yes, sir.
I've had this happen a couple times in the past month or so. Like, well, I thought after I talked to my lawyer, I could just leave, and then, no, that's not how
Yes,
it
sir.
works. And frankly, the lawyers that we have in this courtroom are pretty experienced, and they wouldn't tell you anything wrong like that. So,
Just so the court's aware, I was not present when she appeared in
No,
court.
no, it was,
Let me talk.
I'm sorry.
On the second, I will tell the court that when I talked to Ms. Henderson on the phone, she did tell me, one of the first things she told me was, I thought I had court on the 8th, and I advised her, like, that couldn't be a correct court date, because that's the trial week, so.
Well, and I understand that you were just appointed on the 20th, Mr.
Correct.
Clemens. So there's been some, as Ms. Henderson said, some changing between the lawyers, but that you went from the PD's office to ORCC. So what I'll do at this point is withdraw the Capias because you're here. In fact, I think based on what we talked about the other day, I gave you a bond.
You did.
Which I don't always, I most often don't
Yes,
do
sir.
that, but based on, your lawyer's argument and what he told me on Tuesday, I gave you a bond. I'm gonna withdraw the Capias at this point. What do we wanna do with it from here?
I would ask the court put this on the October 20th.
October 27th at 9 o'clock.
Yes, sir.
And I'm giving her a piece of paper with
Thank
the
you,
date
sir.
and time written on it.
Thank you very much.
It's 25 CF 1268. Lynn Henderson.
All right, thank you, thank you.
Call mom.
Your Honor, if we may call Cameron Gully, 24 CF 84. He's coming to the podium with his grandmother. Ready to proceed? And Judge, at this time, Mr. Gully is going to tender a open plea, no contest plea, open plea to the court on the condition that he be sentenced as a youthful offender. We're requesting, that's the agreement with the parties. We're requesting that the court order a PDR and a PSI and that he be brought back for sentencing. I do have an executed written plea agreement, if I may approach, signed by all
Take a
parties.
look at it. So it's my understanding the state's agreement is it's an open plea, but he would be sentenced as a youthful offender?
That is correct, Your Honor.
Okay, so I wouldn't be making that decision. That's,
It's by stipulation.
okay. I noticed there's nothing checked as far as adjudication or not. That's something I'll make the decision on as well.
Correct, Your Honor.
Okay. Mr. Gully, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Cameron Gully, 01-1009.
09. Whole truth and nothing but. All right. Please.
No.
All right, Mr. Gully, you're here in 20.
Impose the sentence.
Impose what's already been agreed upon?
Well, that can be, currently, right now, that's the plea that's in agreement that's been presented.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their
I wanna make
property.
sure it's
Give us a call
clear,
at
so you don't have to have
850-39.
inconsistent sentences. All right, so Mr. Gully, again, you're here in 24 CF 84. Where you're charged with count 1 is an unlawful use of a two-way communication device, which is a third-degree felony and punishable up to 5 years in state prison. Count 2 is false report of use of a firearm in a violent manner. It's a second-degree felony and punishable by up to 15 years in state prison. Extortion, which is a second-degree felony, punishable up to 15 years in state prison. And count 4 is disturbing a school function, which is a second-degree misdemeanor and punishable by up to 60 days in jail. Do you understand what you're currently charged with?
Yes, sir.
All right. I've been handed a plea and sentencing agreement between you and the state that calls for you to plead what we call open, which means I'll make the determination of your sentence, but with the one stipulation that you would be sentenced as a youthful offender. Do you understand what that means?
Yes, sir.
Have you had a chance to go over that with your lawyer?
Yes, sir.
All right, so the maximum that I could impose based on the agreement between you and the state would be 6 years of incarceration. Do you understand that?
Yes, sir.
All right. And do you understand that if I do a split sentence, which means some incarceration and some probation, it would be a maximum of 4 years incarceration and then potentially 2 years of probation after that?
Yes, sir.
But I could do less. Do you understand that part?
Yes, sir.
Okay. And then we'll have Department of Corrections prepare a pre-sentence investigation, as well as the Department of Juvenile Justice do a predisposition report due to the fact that not only were you under the age of 18 at the time, you still are, right? Yes. Are there any other stipulations as far as the agreement?
I don't believe so, Your Honor.
All right. Mr. Gully, did you go over this plea and sentencing agreement with your lawyer? Did you understand it? Did you sign it?
Yes, sir.
Do you need any more time to speak with your lawyer before you enter this plea? Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
Sir.
Do you understand? Well, let me go back a bit. Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea?
No, sir.
And do you understand that by entering a plea, it's as charged, correct? Do you understand by entering a plea, there won't be a trial of any kind?
Yes, sir.
And we're currently set for trial for next week.
Yes, sir.
All right, so that trial will be canceled if you enter this plea. Do you understand that?
Yes, sir.
Do you understand that you're giving up your trial rights, which are listed on page 2 of the agreement that you signed? Did you have any questions about those rights? Were you able to go over those with your attorney?
Yes, sir.
Do you need more time to do that? All right. And do you understand that you'd be waiving any potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Do you understand that I could adjudicate you guilty and you'd be a convicted felon?
Yes, sir.
Based on that, Mr. Gully, what is your plea to the 4 counts that I previously told you?
Contest.
Based on the agreement with the state for an open plea with the stipulation of youthful offender sentencing, I'll accept your plea as freely, voluntarily, and knowingly given. How long do y'all think you need to get that done?
Your Honor, I would say at least until the end of October on a miscellaneous date, if we may have that. They're going to have to come back from Texas, and with both the DJJ and...
I'd prefer not to do it more than once just because they're traveling. Is someone going to reach out to DJJ to make sure the PDR gets done?
We'll get in touch with you. Somebody will.
Because they usually need at least 30 days as well.
I've just been advised by Cameron's mother, or excuse me, grandmother, that he's scheduled to have a medical procedure at the end of October. So maybe if we have an abundance of caution, we just place it somewhere in early November.
Okay.
Just because they have to travel 13 hours back.
I was gonna ask for, I'm looking at the court calendar and the schedules, maybe December 5th. Would that be too?
December 5th?
December 5th?
Your Honor, I'm looking at the calendar. I don't see a date towards the end of October. We have pretrial going on around that time.
I've got an arraignment date on November 6th. We can always put it on that date.
That's fine.
That work for you, Mr. Keach?
Judge, I'm scheduled to be out of town, but I can make that work, I believe.
Prefer to do it in the morning then?
Yes, sir.
I want to just mention to the court that I may require at least 2 hours for the sentencing.
I think we can just special set it for that morning then, and I'll block it off for any other cases going on to that morning. I just don't want to be a situation like we had, I believe, in a similar case where we had to continue the sentencing about a week because we just had too many cases on the docket that day.
Yes, this would cause a lot of trouble because I have people flying from other states for that sentencing.
All right, so let's set it for Thursday, November 6th at 9 a.m. Mr. Gully, stay in touch with your lawyer. Be back here at November 6th at 9 o'clock. Someone's going to be reaching out to you, I'm sure, from the Department of Corrections as well as the Department of Juvenile Justice to discuss the investigations that'll be done as far as PSI and PDR. But stay in touch with your lawyer so there's not any delay. Again, I don't want y'all come out here and be told we have to continue it because something didn't get finished. That's why I'm trying to put it out far enough for that purpose. All right, anything else?
No, you don't.
No, Your Honor.
Yes, ma'am. Your name, ma'am? Simmons?
CIE, right?
You're right, CIE.
I-E?
Yes, sir.
CIE.
And then S-I-M-M-O-N-S? All right. Happen to have Judge Gontaric's school notes for juvenile up here, so I just edited a little bit.
It's appropriate.
All right. Anything else?
No,
Hey.
no, thank you.
All right, we'll see you back on November 6th.
I can do it right away.
Notes?
Judge, I'm here on Mr. Joseph Lolly's case, 24 CF 1610. Judge, came here trying to tweak an offer that had been made, but then Ms. Leone has just informed me that that offer was withdrawn at the last court date. I don't see that in my note. I think she tried, and she was going down that road, and then we finally stopped and agreed we'd set it for today, and hopefully we can get it resolved. But
All I have is from August 25th. The minute sheet says possible plea on today's date, but I didn't bring my notes from that particular date.
And that's my, if I may, Your Honor, that's my recollection. I didn't revoke it at this time. It was revoked back at last pretrial when he didn't plead.
I don't recall. I mean, I could certainly go back and review it, but I mean, honestly, we all know how the rule works. Until it's accepted by the court, any plea offers can be withdrawn.
so, Judge, then we just simply need to continue the matter to another date and decide if we want to go to trial or not.
Is there anything else that needs to be done to prepare for a potential trial?
Judge, we had gotten, no, I don't believe so, because there had been depositions taken previously, had those transcribed, and I've got them here in my file. I don't believe that there's anything else that would have to be done at this point, but except to review the depositions and then decide if we want to have a trial or not.
Just because the case is over a year old now, I'd like to, if it's going to be a trial, that it be next time.
I understand.
Yes, Your Honor.
All right, so Mr. Lally, I need you to come back on October 27th at 9 a.m. for a pretrial conference. I expect your case will be resolved one way or the other next cycle.
Yes.
Very good, Judge.
Just to be clear, we weren't set for a trial this time around. It was just set for a possible plea, which it's not. So. All right, thank you, Mr. Lally. Stay in touch with Mr. Nobes.
Thank you.
Mr. Kleins, do you have Cook?
Your Honor, I have Ashley Cook. She advised my office. She's on here early. I talked to Mr.
Is there an Alexander Lynch? Make sure. Yes. Your Honor, the state, based on insufficient evidence to be able to prove this beyond a reasonable doubt, the state will dismiss 24 CF 2868.
Dismissed by the state.
I'm going to continue to sit in the gallery till we're done today, just in case she shows up. But
So my look at the docket, we still have Horn and Styverson to figure out, and then we've got the trial so far of Hinesley and Wagner.
Yes, Your
I think that's everybody, right?
I believe so.
I believe so, Your Honor.
Say again? Okay. Ms. Rivers, you know what we're doing on Styverson?
Yes, Your Honor,
Okay, I just wanted to know so I can start making our plans.
Your Honor, this is Dana Nicole Styverson. She's before the court on 25 CF 3. We've reached an agreement in this matter, if I may approach.
Yes. All right. All right, Ms. Styverson, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Dana Nicole Styverson,
Date of birth?
7879, sorry.
Okay, that's fine. Ms. Styverson, you're here in 25 CF 003, where you're currently charged with dealing in stolen property by trafficking, which is a second-degree felony and punishable by up to 15 years in state prison, as well as grand theft auto, which is a third-degree felony, punishable by up to 5 years in state prison. Do you understand your current charges?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would call for you to plead no contest to the lesser included offense on count 2 of petty theft. In return, the state would dismiss or null pros count 1. So the petty theft, it would be a first-degree misdemeanor, right, because it's 1 year probation.
Yes, sir.
All right. 1 year of probation on the petty theft, reserve on restitution for a period of 90 days, $270 in court costs, $50 cost of prosecution, $50 PD fee, $50 application fee, waive cost of supervision due to the fact that you're represented by the public defender's office, and also during your probation have no contact with Jeffrey Johnson. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do today? Is that the state's agreement?
It is, Your Honor.
All right. All right, Ms. Styverson, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Do you need more time to speak it, to Ms. Rivers, your attorney, about it? Are you satisfied with her advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter the plea?
No, sir.
Has anyone promised you anything in return for the plea? And do you understand that by entering the plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
And we're currently set for trial for next week, so you understand that will be canceled and there won't be a trial.
Yes, sir.
Do you understand you're waiving all potential defenses that you may have? And it also calls for a withhold of adjudication, so it won't be a conviction. Do you understand that?
Yes, sir.
All right. Do you understand, even with that in mind, that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Okay, well, I know it seems humorous sometimes, but it's something I have to ask everybody in every plea.
Yes.
All right. And what is your plea to the lesser included offense, count 2, petty theft, first-degree misdemeanor?
No contest.
All right, I'm going to accept your no contest plea as to the lesser included petty theft on count 2. State have an announcement on count 1.
Yeah, the state dismisses count 1 in exchange for a plea to lesser included of count 2.
All right. I'm going to reserve on restitution for a period of 90 days, $270 in court costs, $50 cost of prosecution, $50 PD fee, $50 application fee, waive cost of supervision, no contact with Jeffrey Johnson. It's a withhold of adjudication. I think I still need fingerprints, though, because even a withhold on a petty theft, it can be used as an enhancement, right?
I don't know, Your Honor. I don't know.
Let's take a quick look. All thefts, okay. So I'll still need your fingerprints, even though it's not a conviction, because if you get 3, it can be a felony, even if it was a withhold to begin with.
Yes, sir.
All right, so I'll just need to be fingerprinted. I need to talk to probation before you leave, and then you've got 30 days to appeal the judgment and
Yes, sir.
sentence of the court. Anything else?
No, thank you.
All right, thank you, Ms. Styverson. All right, so Ms. Rivers, I think you have to go talk to Mr. South. Is that what we're waiting on?
Yes, Your Honor.
All right, take your time. I just want to make sure I've got everything figured out.
mistake, was not brought over this morning. He's here now, though. I just met with him.
You have met with him already?
Yes, I did. That's what I was doing 5 seconds ago. Yes, I believe I am. Come stand over here, Mr. Horn. All right, Judge, this is Joseph Charles Horn. The only, I had looked at potentially doing a motion eliminating in his case too, but some of those questions I found answered in the report. The only thing that I have left is if the state can shoot me a copy of the warrant. I think I asked you about that in court before, and I'm sure it just slipped your mind.
I'm
I don't
sorry.
need the affidavit, just the actual warrant.
What warrant?
What warrant?
The warrant for the phone dump, unless you're not going to use the phone dump.
Oh, yeah, no,
And it's referenced in the reports. The physical warrant, according to the reports, is in the bag with the phone.
okay, I will provide that, but,
Other than that, Judge, I think unless I see something earth-shattering in that, I think we're ready to go on this. Again, I would ask or suggest this may be a good case for the second.
The problem is, that's what everyone said so far.
Yeah.
if I may, Your Honor, because by now, some of the cases that were set were resolved, my suggestion would be to do Mr. Wagner next week,
Okay.
because I do have witnesses subpoena for both weeks in that
So
case.
let's wait till Miss Rivers comes
Y-
back.
yes.
I understand, I just don't want to talk anymore about the case unless she's here, but for scheduling purposes, obviously, if we do at least one of them next week, otherwise, to do 0 next week and 3 the following week would probably be not the best use of our time. Just because we'd be scrambling to make sure to get them all done, pick 3 juries potentially in one day. How long of a trial do y'all expect this to be, 1 day?
Excluding jury selection, I think 1 day is sufficient.
Let's get Ms. Rivers back and we can discuss the last bit of it. Obviously, we're waiting on what's gonna happen with Mr. South.
Yes.
But otherwise, I think it looks like we just got the 3 for now.
Yes,
Trials.
yes.
Yes, sir.
I think we could potentially do them all in 1 week, but
No,
they'd all be your cases, right, Ms. Leon?
yes.
So you probably don't want
I
to do that
believe
either.
Mr. Shiki is gonna handle Mr. Wagner's case.
Yes, Your Honor.
All right, let's see. Point this out, that would mean that both you, Mr. Williams, and you, Ms. Leone, would have both of your trials in the same week, if you did
Yes.
it that way, okay?
Yes,
Yes, sir.
should be okay.
All right, well, I guess we'll just wait for Ms. Rivers on South and confirm that we only have the 3 left.
Yes, sir.
All right. Mr. Horn, we'll probably bring you back just to tell you what week you're going and what potential day. I think we can try to figure that out too. But, and we'll just figure out which, it looks like the second week, so it wouldn't be next week, but the following, but we want to confirm all that once we get all of our ducks in a row.
Just next Friday, I've currently got scheduled a diabetic eye exam,
You don't
but
have to
that can
give
be
the details of it, Mr.
passed
Williams,
off.
but I don't expect, well, that's next week.
Yes, sir.
We're talking
next-
about putting both of yours the following week.
Yes, sir, that's the plan, but if something happens, that's my only scheduling.
Okay, all right.
Thank you, sir.
Thank you, Mr. Horn. Rivers, do we need Mr.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
Your Honor, we've reached.
Yes. Thank you.
And Your Honor, this is going to be a best interest plea.
Okay, just to make sure, earlier was talked about 20 months, but the score comes up to 22.8. That's what y'all are doing?
Yes, Your Honor.
Yes.
And I've reviewed the score sheet, so. All right, Mr. South, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
Richard Lee South. November 25th, 1953.
All right, you can put your hand down, Mr. South. Thank you. Mr. South, you're here in 23 CF 1796, where you're currently charged with attempted first-degree premeditated murder with a weapon, which is a life felony, which means you can be sentenced up to life in prison for such a charge. Count 2, burglary of a dwelling while armed with a weapon, also a life felony. And count 3, aggravated battery with a deadly weapon, which is a second-degree felony punishable by up to 15 years in state prison. Do you understand all that?
Yes, Your Honor.
All right. I've been handed a plea and sentencing agreement between you and the state that would call for you to plea as charged to count 3, the aggravated battery with a deadly weapon. In return, the court, pursuant to the agreement, would sentence you to 22.8 months in the Department of Corrections. Appears you have credit for that already. I believe you've been in for approximately 2 years. Is that right, Mr. South?
Yes, Your Honor.
Okay. So I would give you obviously credit for time served. They have to do the calculation, but it seems to be pretty clear that you'd be released today.
Your Honor, if I may, we are the state is stipulating that he does have
Okay.
that credit.
Trying to prevent him having to wait, get sent to DOC, only to be back. This would allow him processed out
Okay.
here at the Okaloosa.
All right, so the state is stipulating that Mr. South has already served at least the 22.8 months.
Yes, Your Honor.
All right. That wasn't in the plea agreement, so I just want to make sure that's clear.
Yes.
All right. Also, Mr. South, you'd have to pay $867 in court costs, a $100 cost of prosecution, $100 PD fee, and a $50 application fee. I can give you a period of 60 days from your release to either pay those fees or set up a payment plan with the clerk's office. Do you understand that?
Yes, Your Honor.
All right. And the state would, in return for that plea, would dismiss or null pros counts 1 and 2.
That is correct, Your Honor.
Okay. And has the state fulfilled its obligations under Marcy's law?
Yes, the state has.
Okay. All right. Mr. South, have you gone over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Do you need any more time to do that?
No, Your Honor.
Okay. Did you understand it?
Yes, Your Honor.
Did
Yes.
you sign it?
Yes, Your Honor.
Okay. And are you satisfied with your lawyer's advice and representation?
Oh, yes, Your Honor.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No.
Do you understand that by entering a plea to the aggravated battery with a deadly weapon, that there won't be a trial of any kind?
Yes.
And do you understand that you're giving up your trial rights that are on page 2 of the agreement you signed?
Yes.
And we're currently set for trial for next week, but that will be canceled because of your plea. Do you understand that?
Yes.
All right. And do you understand that you're waiving all potential defenses that you may have in this case?
Yes.
And do you understand that if you're not a U.S. citizen, this plea could lead to your deportation?
Yes.
And you'd be adjudicated guilty, which means this is a conviction for a violent felony.
Yes. Yes.
Excuse me. And this is the entirety that I've read. This is the state's agreement, correct?
It is.
All right. And I've also reviewed the score sheet, which as edited based on the state null processing counts 1 and 2, would lead to 58.4 points and a 22.8-month lowest permissible prison sentence. Any objections, Ms. Rivers, to the score sheet?
No, Your Honor, I did review it with my client.
Yes, ma'am.
Based on all that, Mr. South, what is your plea to count 3 aggravated battery with a deadly weapon?
No contest.
I'm going to accept your no contest plea to count 3 aggravated battery with a deadly weapon as freely, voluntarily, and knowingly given. I'm going to sentence you, I'm going to adjudicate you guilty, sentence you to 22.8 months in the Department of Corrections, give you credit for already completing 22.8 months based on stipulation with the state. Again, my quick look at it, that this, I think you were arrested in August of 23, so that would be over 2 years that you've been incarcerated awaiting your trial. $867 in court costs, $100 cost of prosecution, $100 PD fee, and $50 application fee. State having announcements as to counts 1 and 2.
Yes, Your Honor, the state dismisses count 1 and 2 in exchange for a plea to count 3.
All right, Mr. South, I'm going to need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Okay.
All right.
Yes, sir. Yes, Your Honor.
Any questions?
No, Your Honor.
All right. All right, thank you, Mr. South. Step over to be fingerprinted.
Thank you.
There might be a page missing from the guidelines for Mr. South.
May I?
All the information is on here and correct, but the section that I signed, it doesn't seem to be here. Trying to find if I lost it up here somehow. Rivers, any chance that you've got it?
No, Your Honor.
I have another, I can just grab another one. Oh, yeah, no, because that's, you should have, may I approach?
Oh, look, it's literally, it was stuck together so well that, okay, there it is. I mean, I was literally trying to push it together because it just it felt like a thicker page, but it would not come apart. All right, got it now. I think that takes care of all of our cases other than the 3 trials. So everyone had asked for at some point week 2, but I think it would probably be beneficial to put at least one of them in week 1. So my understanding is y'all have now requested maybe Wagner goes in week 1.
Yes, Your Honor. I'm good with that. The only request is if it can possibly put towards the end of the week. The reason I say that is I've got drill this weekend, and I don't want to, I want to make sure I do my due diligence on it, Your Honor.
And also, we have to get his clothes.
Okay, so what day do y'all think? Y'all want to pick and go Thursday?
It's your
Yeah,
preference.
I mean, if we want to
Or pick Wednesday, go
pick Wednesday and go Thursday.
That works. Good with you?
All right, and
And-
how many, go ahead.
Your Honor, as I've mentioned before,
I was just about to ask the question.
based on the newspaper.
How many do you think we need?
Well, the state is gonna have, the parties are gonna have 6 peremptory strikes. I would say 40.
Dave,
Okay, so 50 for Wednesday next week, which would be the 10th. Okay. Anything else that we need to talk about? Any motions in limine expected?
Don't think we have.
No, not on this case.
Is there a date you want preliminary jury instructions or anything? Do you want that today, or?
If y'all get them to me by Tuesday, just so I have a chance to look at them.
We can
Yes,
do
Your
that.
Honor.
I'll
That's
get that.
more than enough time. I wasn't saying that.
No, I
could do it
just,
earlier.
I just realized, because that nothing's going until Wednesday now, as I just canceled my dentist appointment for Tuesday morning. It just dawned on me that I could have kept it. Maybe I'll call him after this.
So I guess the only thing I was going to inquire if we're ready is for the second week, how the court would like to handle it. The 2 trials left, like if we want to pick both juries on the Monday.
So that would be both you and Mr. Williams on both of those. All right, we'll see you next Wednesday.
But I let Mr. Williams, of course, express his
How do
opinion.
y'all suggest as far as when you want to pick the jury and which one goes first? And so I think we've got a 1-day and a 2-day, right?
Yes, sir.
Yes.
And I don't really have any preference. What I'm used to is picking all my juries on Monday and then going to trial sometime during that week. I normally want to avoid Tuesdays, although it's less of an issue on the defense side of it than it is on the prosecution side. Just so you have that extra day to.
I understand, but if we're going to have that Tuesday be clear, then we'd have to pick both juries on Monday. Because one is going to be 2 days.
Yeah, my only fear with that would be that if we pick both juries on Monday, then we start, I would like to set Mr. Hinesley's trial before Horn. That's gonna be 2 days, so that's gonna end up on Thursday, Wednesday and Thursday, if we don't do anything on Tuesday. And then for Mr. Horn, we're only gonna have 1 day. I'm afraid that what if, I don't know.
I think I can go on Tuesday.
Well, would you rather pick the Hinesley jury on Monday, go Tuesday, Wednesday, and then pick and go Thursday for Mr. Horn?
Judge,
Or
I
even
can
pick
also-
Thursday, go Friday? And it's,
For me, would work, whichever way works for the court and Mr. Williams, that
I've got to
doesn't
be
matter.
here every day. Y'all know that.
Me too.
It doesn't really matter how y'all want to do it. I want to make it most convenient for you guys.
May I maybe ask court security if they have a preference?
I don't think they have a.
No, as far as bringing
And
the
fully
whole
staffed.
jury veneer on 2 days versus only on Monday, that doesn't matter? Okay, then.
Yeah,
Okay,
they're going to
Judge.
be here, and my office has confirmed with jury management that bringing in a jury on a Wednesday or Thursday is possible as well.
Okay, then, whatever.
Judge, the advantage to doing them both on Monday is that the general questions, reasonable doubt, presumption of evidence, we only have to do that once.
So you would just have everybody in the room and pick 2 juries out of it?
Well, yes, that's the way that we've always done it. I can't think of anything in particular about that would necessarily poison the well in the other case. Drug case, one is a sexual battery case. But I'm good with doing them on separate days and doing pick and goes too, Judge. All the Jimmy Rice cases were always pick and goes. I've done other cases.
All right, so does the state have any preference?
Well, one issue would be that, in this case, Mr. Williams, it would be the same attorney, so both defendants would have the right to be present during jury selection. if we're doing it at the same time, obviously.
I think that, Mr. Williams, I think that potentially puts you in a difficult situation of having two clients that you're trying to talk to at the same time. One's in custody, one's not.
Well, Judge, the way that I'm have done it in the past, that is routine in Escambia and Santa Rosa, is both defendants are present all defendants are present during all the jury selection. We call that case up, we do the selection on that case, and then, you know, when the real issue is if the first guy is a jail individual, making sure that the jury in the second, the jury doesn't realize that he's going back to lockup. And then, you know, just ladies and gentlemen, I asked you all about reasonable doubt.
I understand the concept, Mr. Williams.
Let's just do it as a pick and go. It seems to me
I think it would be easier that way. It's one thing if there's two different defense lawyers
Yes.
who have to speak with their clients during the course of it, and splitting you between two different clients at the same time just seems like a potential recipe for problems.
I believe that the best way would be to pick and go for Mr. Horn on, you said Thursday, yes, Thursday.
So what we'll do is we'll pick Mr. Hinesley Monday, the 15th?
Yes, Your Honor.
Go Tuesday, Wednesday with his case.
Yes.
And then
Talk to me.
Thursday, we'll pick Mr. Horn. Do you guys want to go pick and go, knowing that we'll probably go into Friday? Or just
Yeah.
start Friday? It's really up to y'all. I don't, y'all said one day, but I don't know if it's kind of a 1 day plus or not.
You know, things always happen. I would say that we pick and go, we start on Thursday, and then we continue on Friday and end it.
This would be my suggestion, Judge. Wind up needing more time on a Friday and work folks in, pay them overtime on the weekend. Out and about.
And for Mr. Hinesley, how many jurors do you think you need?
Judge, go maybe a little higher than usual. The fact, I don't think we're going to, if 50 seems like too high, 30 or 40.
I don't think I'd want to go above 40. Okay. Just it's been my experience so far in picking juries this year that I don't think we've ever got much past 40, and those were on cases where there were 10 challenges per side and very kind of issues that lead to a lot of cause challenges.
Yes, I'll be fine with 40.
All right. What about for Mr. Horn?
Same?
I'm going to say, yeah, the same. Okay, sometimes.
I mean, I want to make sure we have enough, but I also don't want to have, 10 or 20 people sitting around probably never having much of a chance to even get on the jury. But so
Yes,
I'll go 40 on Hinesley, 40 Horn, and then 50 on Wagner that we talked about. But they're all different days.
Yes.
Just to recap, Wagner will go selection on Wednesday, September 10th, 50 jurors. We expect that to be 1 day. Hinesley would go Monday, September 15th for selection, trial starting Tuesday the 16th. Continuing on the 17th, 40 jurors. Horn would be Thursday, the 18th. Basically a pick and go so we can make sure we're done by Friday.
Yes, Your Honor.
Not keeping jurors on a Saturday. Assuming they don't need extra time. And 40 jurors for that one. All right. Anything else?
No, Your Honor, I will send you jury instructions early next week, even for the second week. And you mentioned that you want the final instructions and only the charges for the preliminary.
Yeah, we can, I could just, I've got the whole book. I can just stick in the statement of the charge type.
Yes, that's
deal
fine.
with that, so we'll be fine with that. If anything comes up, motions in limine that need to be filed, I don't like doing that when jurors are waiting. We've got potentially some days available next week if needed. Again, I'd always prefer that they're done before today or at today's date. But if something comes up, let's make sure we get it done in a timely fashion or discuss it amongst yourselves if it can be worked out.
Yes, sir.
All right. Anything else?
No, Your Honor.
Nothing from me, Judge. All right. Mr. Hinesley? Yes, sir. Not this Monday, but next Monday.
All right, anything else to address?
No, Your Honor, thank you.
All right.